Hello, and welcome to In the Privy Council, a weekly podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style blog. I'm your host, Elijah Granite. This week, we are discussing the Cayman Islands case of HEB Enterprises Limited and Richards, the citation for which is 2023 UKPC 7, CAY. This case concerns contractual interpretation, as well as, excitingly, a question of consideration. It begins in 1994, when Mr. Richards, or the buyer, signed a purchase agreement with HEB Enterprises, or the seller, for title to 2 lots in a shopping complex on Grand Cayman. As part of the purchase agreement, the buyer paid a deposit on the lot and agreed to pay the balance of the purchase price over a 20-year period, along with 12% interest. At the end of that 20-year period, the buyer would acquire the title to the lots. Clause 5 of the agreement provided that the possession would be given to the buyer at completion, or earlier if the sellers expressly consented. The plan was, however, clearly for the buyer to take possession soon after the agreement, which he did. Over time, the buyer fell into arrear, and in 2016, the seller refused a check for part of the arrears and wrote that the buyer had defaulted. Subsequent to that, the buyer's attorneys wrote to the seller, demanding the return of the payments and interest on the lots over the previous 22 years, in accordance with Clause 6 of the contract, which provided for the return of funds in the case of explicit rescinding by the seller. To be clear, the buyer's attorneys were thus asking, in effect, for the buyer to enjoy the possession and use of the lots for decades, rent-free, because all the annual payments and interest would be returned to the buyer, less the deposit and the cost of repairs under Clause 6. Unsurprisingly, the seller was not inclined to pay this, and the matter went to court. At first instance, in the Grand Court, my Lord, Mr. Justice Williams, held at first instance that Clause 6 contractually prevented the seller from claiming any additional funds back, besides those allocated to them under Clause 6. In the Court of Appeal, my Lord, Justice of Appeal Sir Bernard Ricks, giving the lead judgment, applied the principles of restitution to conclude that the buyer had been unjustly enriched by the failure of the contract between the two parties, and thus owed money from the mean profits, that is, the profit the buyer received in possession of the land, to the seller, in an amount equivalent to the interest paid. This was due to a concession by the sellers, who no longer sought all the mean profits. The transaction was clearly centered on possession by the buyer, and it would be unjust for the seller to have to return all the payments, while the buyer retained the principal benefit of the structure of the purchase contract. The buyer, in turn, appealed to the board, where we resume the case. For the board, my lord, Lord Kitchen, began by considering the nature of the agreements for the lots. For example, the high rate of interest on the payments over 20 years only made sense if the buyer had the right, in the meantime, to take possession and use the lots, or else why agree to a 20-year payment plan at 12% interest? The agreements were reciprocal. After the deposit, the buyer would make use of the lots for business, and the sellers would receive regular payments over time while holding on to the title until payment was completed. This basic nature of the agreement informed the board's analysis of the question of the recovery of funds under Clause 6. The buyer argued that the contract does not allow for any recovery other than that which is explicitly stated, and the only claims against default allowed are those under the contract. The board rejected this argument in the strongest terms. Quote, "The buyer's argument founders because he has had the benefit of the right to occupy the shops and use them for his business purposes for the many years since their construction, and to do so rent-free. It would have made no sense for the parties to agree that he would have had that benefit, and yet, on his default, towards the end of the installment period, and as the date for closure drew close, have the right to recover all the payments of interest that he had made." End quote. The buyer thus lost on that claim. The final question was with regards to a novel argument raised by the buyer, the failure of the agreement on the basis of consideration. This argument was grounded on the fact that the contract was for the transfer of title, and the buyer had not received the title. Well, the buyer had received possession, and possession over quite a lengthy period of time as it happened. The buyer argued that this was not part of the written contract, and that the contract as written only showed transfer of title as the consideration moving from the seller to the buyer. However, this argument was ill-founded, the board held, because, quote, "The written contract does not represent the entire agreement between the parties in respect of either lot. It was misguided, therefore, to argue that the payments, which did not commence until the buyer took possession, were somehow unrelated to possession. To claim afterwards that the possession was a side accident was unrealistic. Repeating its basic point on commerciality, the board held it would indeed have made no sense for the parties to agree terms for payment of the price in installments over 20 years at a significant rate of interest if the buyer did not have the right to take possession for that time and to use the premises for his business purposes. As therefore the buyer had received possession as part of the agreement, the board noted that it could not be said to have failed for consideration, since failure for consideration must always be total and cannot be partial. They cited for this point, among others, Fibrosa S.A. and Fairbairn Lawson Combe Barber Limited, 1943 AC 32, HL. Thus, this argument failed, and the board held for the seller, finding that the contract did not confer a right for the return of payments on the interest already made in the event of default. Turning now to our analysis of the case, 3 points emerge. The first is about the construction of contracts. The most common misconception about law is that it is hopelessly literalist, but this case reinforces that contractual interpretation must always take account of the business context and, frankly, common sense, which informs the parties agreeing to a contract. Sometimes that means a contract is not held to be the complete and exclusive codes between the two parties, and clauses have to be read in. To do otherwise would lead to imagining an agreement which no one in their right mind would sign. Taking this approach to contract construction helped the board avoid both the unjust result at first instance and the, with respect, more tortured restitutionary path pursued on the first appeal. The second point is about consideration. As fun as it is to see arguments about consideration come up, they will rarely succeed outside of law school problem questions. But one must admire the boldness of Mr. Jack Watson, counsel for the appellants, in raising a consideration argument. It was never a realistic one. To some extent, the fact that consideration was even raised here was a sign of the fundamental weakness of the buyer's case. Finally, a point of drafting. The excerpt from the agreement in this case shows a fairly sloppily done piece of work. The board acknowledged this by tastefully adding in brackets sick to one of the errors. This litigation could have been avoided by a better contract between the parties, and the fact that this dispute over 2 lots in a shopping mall made it to the Privy Council is a sign of bad draftsmanship. Pay attention to drafting and errors in the first draft, and you can avoid litigation like this. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter at legalstyleblog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and God save the king.